sir. Good afternoon to you. Sir, can you unmute your mic, please, sir?
Good afternoon.
Very good afternoon to you, sir. So, ladies and gentlemen, this is a great honor and privilege for us to welcome Justice B.N. Sri Krishna, and he's a retired judge of Supreme Court of India. He has added so many reform committees, but one of the recent one, which is the most important one, is personal data protection. He has formed these regulations, and it is said that these personal data protection recommendations with Justice Sri Krishna has recommended, these are far more stringent than GDPR. And all of us, we are concerned about protection of our data, our personal data. So without any ado, sir, I would like you to start your session. Thank you. Thank you so much, sir.
Thank you, Mr. Devi. A good afternoon to all of you viewers who are logged in. I've been persuaded to come onto this platform and talk about data protection law in general, and particularly about how the data protection proposed law which is still hanging fire. Before I start to talk in terms of data protection, personal data protection bill, it is not how the data protection is going to be affected by all this law about. Before different people talk differently about this, and unless we are sure of what is it that we propose to achieve by the law, we will start with all this law about. Different people talk, yes, we are sure of what is it that we propose to achieve by the law. The background to this, how it was conceived of, how it was put into effect. So let's start with the background to this project and what the future probably will hold for us. Now, to start with, there has been a controversy in this country on this question whether personal data of an individual is to the test of his private right, which is of the nature of a fundamental right. I'm sure all of you understand the distinction between a fundamental right and an ordinary right. An ordinary right is something that is granted by an enactment either by Parliament or the state legislature. And if the legislature wants, it can withdraw it, modify it, or add to it. But a fundamental right is something that is protected by the Constitution, and unless it is affected by some of the parameters indicated in chapter part 3 of the Constitution, no one can touch it, not even.
Sir, looks like there is an internet issue at your side. Your voice is breaking.
Oh. Can you hear me now?
Maybe perhaps, sir, what we can do, we can switch off our video so that at least we'll have a good quality of audio. Looks like, yeah.
Okay. Now is it better?
Yes, this is better, sir. This is much better.
Okay, I'll continue. So the question that I was posing was the distinction between an ordinary right and fundamental right. A fundamental right cannot be tampered with, cannot be abridged, cannot be in any way restricted, except by a complicated process that has been prescribed by the Constitution. Now the question was, is there a right of privacy which can be treated as a fundamental right? The matters ultimately had reached the Supreme Court in several cases. But the Supreme Court itself was not sure of it, and there were contradictory judgments. Some judgments taking the view that right to privacy is a fundamental right, whereas some other judgments took the view that right to privacy is an ordinary right. Now, in this state of affairs, the issue of data privacy became very important because Europe started considering it. The GDPR was slowly taking birth in Europe, and everywhere, all over the Asian countries also started recognizing the importance of data and its privacy. In the meanwhile, what happened is that the government of India thought of introducing the Aadhaar card, which is known as the unique identity card. Actually, in most of the civilized countries, you have this unique identity card in different forms. Now, a special department and a special authority was provided with the stupendous task of evolving an identity card for all these 2 billion people or 1.5 billion people of this country. Now, when this Aadhaar card was initially proposed, it was proposed as a departmental enterprise. There was a lot of objection to it. Activists and civil society objected and said, how can you do this? And then a special act was passed called the Aadhaar Act. Now, this Aadhaar Act and the manner in which it would infringe on the rights of the citizens were questioned in a series of writ petitions led by one Justice Puttaswamy, who was a former judge of the Karnataka High Court. The matters ultimately landed up in Supreme Court, and the Supreme Court, while hearing the matter, raised an important question and said, hey, you people are complaining about this right being taken away. Why do you say it is a fundamental right? Who said it is a fundamental right? So then there was a lot of consternation. Then the number of judgments were pulled out and shown. The Supreme Court thought that there were contradictory judgments, and therefore we should have the law laid down by a larger bench. So a larger bench of 7 or 9 judges was formulated, and thus held first the question of what is a fundamental right to privacy, whether it's a fundamental right or not. There was a lot of debate on that. There is a very long judgment which if any of you have the patience to read, you can read. It's reported in the law books. Finally, the Supreme Court came to the conclusion and said, hey, yes, we must recognize right to privacy as a fundamental right. But like all other fundamental rights, it can be restricted or infringed only if there is a parliamentary enactment which declares the objective for it and does not go beyond this doctrine of proportionality of doing something more than what is required, and a methodology is established for restricting the fundamental right. After that, the matter came back before the Aadhaar court and it was being heard. At that stage, the court raised a very important question and said, hey, this was addressed to the government, and he said, hey, where is the law in this country on privacy and right of privacy? So again, the government went into a buzz, and then I was about to leave for New York on a midnight flight, and I get a frantic call from the law minister saying that we want to start a committee to go into this question and examine it and formulate the law. Would you please accept the chairmanship? I said, hey, look, I'm on a vacation for 2 months. I had just finished another committee meeting and I was about to go away. Finally, I was persuaded to do it. And finally, the committee had 10 members. We sat around. We decided that whatever the proceedings of the committee and whatever deliberations should be available to the public at large. The public should be invited to say what they want to in connection with this, so that we will be able to interact with the public properly and bring about a law which will be more consensual than being forced down on the throat of people. Now, finally, we had a lot of deliberations and then published what is known as a white paper. The white paper examined the law with regard to right to privacy and personal data protection all over the world. At least the major countries which had enacted laws which made some sense to us, like GDPR, and then in those days America was not even on the scene. Estonia, Singapore, Australia, South Africa, and all that. Finally, we produced a sort of a consensus on what could be the terms on which the law could evolve. That was put forth in the public domain in the form of a white paper, and the committee also went and held public interactions in 5 or 6 major cities with regard to the white paper. Lot of responses came in also from abroad, from professors, academicians, lawyers, research scientists, students, and ordinary human beings. After considering all that for about a long period with a lot of interactions and discussions internally, finally a bill was proposed, a report was proposed, and along with a bill which was sent to the government. Now that bill was moved in Parliament with a lot of modifications. But considering the serious and complicated nature of the issue, the bill has been referred to the Joint Parliamentary Committee and is pending there to be finally given the shape in which it will be passed in Parliament. Now, this is the history of how the Personal Data Protection Bill moved in this country. Now, before we understand what are the pros and cons of the bill, it is necessary to understand what exactly are the fundamental concepts in right of privacy. First of all, we must understand what is data. Data is something that it indicates or connects a human being to it. Now, that could be in the nature of what? Somebody's name, somebody's address, telephone number, photograph, name anything that gives you an indication of to whom that person, that data is relatable. Now, the next question is, there is a lot of talk about data being the oil in this millennium, and that it should be owned by people and it should be monetized and all. Now, jurisprudentially, to say that data is anybody's property is incorrect, because all property in the law that stands in this country today is either movable or immovable. If it is immovable, there is
Sir, sorry to interrupt you. Can we try activating the video? Let's see if the internet bandwidth is stabilized.
Okay.
We'll have a privilege to see you as well.
All right.
And all the audience.
Now it is a very good sign. Is it okay?
Yes, sir. If anything goes wrong, I will again interrupt you, sir.
Okay, no. Yes, sir. I was saying, prudentially, what is this right to data? Now, is data somebody's property? As I told you, all property is either movable, like say your.
Sir, looks like again, sir. Sir, I think the voice is again breaking. I think we should go ahead with only audio. Now I'll not interrupt you. we should turn off the video. Yeah. Thank you, sir.
Okay, can you hear me now? Jurisprudentially, what
yes, sir.
All property is either movable. Is that okay? Right. In this country is governed by 2 laws. If it is immovable property, there is a separate law for it which deals with it. If it is movable property, like the Sale of Goods Act or some other acts, there is a separate act for that. Now, the interesting thing is, what do you consider data as? Movable property or immovable property? Now, if you consider data as property at all, then the property laws empower you to transfer data to another person by several methods. Now, one can be sale, the other can be gift, the other can be mortgage, There can be a charge on that, or there can be some kind of other interest created in it. Now, if you consider, for example, immovable property like a house or land, I can sell it outright. I can gift it to somebody for no cost. I can rent it out to somebody and charge a lease or a rent. I can also uh, create a mortgage on that temporarily by raising a loan on that. Now, can you do that to your data? Let's take my name is my data. Is it possible to sell it to somebody outright? Can I say I will give it on lease to somebody for 6 months at a stipulated rent? Or can I gift it off to somebody for permanent use without any cost to them? So these are the difficulties that arise if you talk of data as a property. Jurisprudentially, all now when you say this is my data, what are you saying? You are using the genitive case. The genitive case in grammar relates a relation between the two objects. A relation need not necessarily be a proprietary relation. If I say this is my book or my car, I am suggesting that I have proprietary right over this. But if I'm saying this is my friend or my wife, I'm not suggesting a proprietary ownership on that. Therefore, it is possible to have an entity used in this sense, which will only show a relation, an intimate relation. Coming down to data, when you say this is my data, I'm not suggesting that I'm the owner of the data, but I'm only suggesting that there is a close and intimate relationship between this data and me. Now, that is an intimate relationship of being able to identify me. Then there could be several types of data. For example, something like my name. There is enough of my name in the public domain. Therefore, there is nothing sensitive about it. But there could be something very sensitive. For example, the health data of a person, the political idea of a person, or the ideological associations of a person, whether I am a member of this society, that society, etc., etc. All that is data, but that is sensitive to me. It could also be some passwords. It could also be my number of bank accounts I have and details of bank accounts. These are all sensitive data. Then there is a third category called critical data. Frankly, critical data can only be a very restricted number of persons. Now, if a person holds a function which is very, very critical to the country, like say the Chief of Army Staff, the Chief Justice of India, the President of India, the Prime Minister, his data, personal data, is very critical, not because of anything else, but because of the fact that he plays a role which is very critical and vital to the country's affairs. Therefore, that would be called critical data. Now, how each one of these sets of data has to be dealt with, we'll come to in a short while. Then there is another question that arises in data protection, that when I have my data and I want to utilize it for the benefit of myself, what is it? There is a process of transfer of the data. Now, for example, if I go to a shopping mall, let's say I just go to a hotel and I want to stay there. The first thing they will ask me is my name, my address, my telephone number, my email, ID, and also probably a passport or an identity card. All that is necessarily my data. But I am giving it for the purpose of what is an overriding security and for the purpose of ensuring that I get a room in the hotel for this period that I propose to stay there. Or let's say, and when I go to buy an airplane ticket, again they ask me a whole lot of my data, which I transfer to them, and they accept it for the reason that they are going to issue me a airplane ticket, which will enable me to travel. Take a case where I go to a shopping mall. You will notice that in the shopping mall, there is always a security camera. Now, I am not giving them anything, nor are they taking my consent. The camera takes my picture. That is for the purpose of security. So the basic tenet in data processing is that there should be a consent of the person whose data you are processing. This transfer and using it in some manner or the other, or even storing it, is called processing of the data. Now, the bottom line is data cannot be processed without the consent of the person. Now, there could be several exceptions to this rule under certain circumstances, which I will point out shortly. Now, this data can be processed without consent under some circumstances, exceptional circumstances. For example, let's say somebody is knocked down by the car on the highway or in the streets of the city. That person's, the primary thing to be done then is to save his life or to mend his limbs which are broken. Therefore, he is taken to a hospital. The hospital, of course, needs data. And they say, hospital says, give me all this data, including his whatever you can give him, blood count or blood pressure or whatever medicine that he can he normally takes. All the data at that point of time may be taken without his consent, which can be utilized. It's somewhat similar to a situation that if somebody is dying and is about to be operated upon, and you do not know of any of the friends or relatives, you can't say that unless some relative comes and takes responsibility, I'm not doing the operation. You have to do it then and there. Take also situation that somebody is admitted in hospital X, and the hospital X thinks that it is not possible for them to handle the problem. They need the patient to be transferred immediately to some other hospital. Then they have to transfer the data. At that stage, it's not, you cannot sit down and ask him and say, give me your consent. Then there can also be situation where consent would have to be implied, like I told you, when you enter into a shopping mall and the photograph is taken, or you're driving on a highway or even in the city where for speeding offenses, automatically your photo is taken. All that is my data, and it is being taken without my express consent. Then there is another interesting question of not being able to give consent or inability or non-requirement of consent. I must draw your attention to the fact that while in the long judgment given by the Supreme Court in Puttaswamy's case, they pointed out one thing, that all fundamental rights have to be necessarily subordinated to the state's actions under certain circumstances. For what purpose? For the purpose of ensuring that the fundamental rights are properly exercised by all the citizens. Take, for example, I have a fundamental right under Article 21 to right to life, and then I can move anywhere I want. That is my fundamental right. Now, if there is a situation of riots, if there is a situation of, take even your pandemic, COVID-19, where walking on the streets is dangerous to me as well as to the other citizens, the state will have to be given the right to access the data and ensure that my rights are curtailed pro tem only for a short term till the emergency situation is resolved. That is why in Puttaswamy's case, the Supreme Court said there are the three fundamental principles based on which you can pass a law and then curtail the take away the fundamental right to privacy of a citizen or a non-citizen resident in India. Which are those circumstances? Take, for example, that there is some criminal investigation to be done, or there is investigation to be done in connection with terrorist activities, or with leaking of military secrets, or something that is disastrous from the point of view of the country's economy, or from the point of countries of security or foreign relations, as they call it. Now, in such circumstances, obviously, you cannot go and, supposing there is good ground to think that I am a terrorist, naturally all the telephone calls that I made, the persons that I met, the transactions that I have made, the emails that I've received and sent are very important in the line of investigation. Now, it cannot be done with my consent. Therefore, it is possible in such circumstances to take it without my consent. But then, as I will point out later, that has is subject to severe restrictions which have to be necessarily obeyed. Otherwise, in the law as such, it will be illegal. Now, how does this law apply? It applies in order to, first of all, let me tell you that the law is intended to apply to all persons resident in India, including citizens and non-citizens, to all companies registered in India, all trusts registered in India, all other business entities registered in India, unless they are exempt because of some nominal. Now, the corner BD shop or the man who sits on the street corner and repairs your shoes is not going to be bothered about this law. This law will exempt him. Otherwise, whether you take data and store it, whether you take data and process it, whether you take data and hand it over to somebody else to process what you cannot process, everything is intended to be covered by it. Now, that is why the definition of processing is very wide, which includes even mere storage. For example, if I go to a bank and open a bank account, the bank will naturally ask me data of 100 kinds in order to ensure my creditability and creditworthiness. And all the data is stored either in, it used to be stored all these days in a register. Now it will be perhaps stored on a computer or on their server. Now, processing of data would therefore have to be by consent of the person whose data you are taking. Now, this consent will run into some difficulty, as I told you, in certain circumstances. Incidentally, I must mention, all over the world, the person whose data is being taken for processing was called data subject. And they, when it came before the committee, I raised an objection and said, hey, the last time we were subjects of Queen Victoria and Queen Elizabeth. And I don't like to be called anybody's subject today because I believe that this country and myself have become, this country has become a republic, democratic republic, and I am a free citizen of this country. Therefore, I refuse to be called a data subject. So what is the name to be given? So we said, it is my data you are taking, so call me data principal. So the bill uses the word data principal. And what is the person who takes the data for processing to be called? I'm giving it to him on trust. Trust. What is the trust? That you will use my data only for this purpose and for nothing else. Therefore, he is a data fiduciary. Fiduciary is a term used in law to denote a situation of trust being reposed in that particular person. Therefore, as I was telling earlier, the and how much should the consent work for? Now, what will happen is, if I give my data to somebody for processing, now let me give you an example which is not from data, from the point of view of everyday. Let's say I have a problem with my car. I take it to the garage for repairing. The garage man says, sir, I can repair your car, but it requires a little bit of reboring, and that I am not in a position to do it. Can I send it to another person for reboring of the engine and bring it back and do the rest of it? I say, okay, do it. So what he has done, processing on my car has been transferred to somebody else. Now this works exactly like this in the situation of data collection also. Somebody collects my data, but he is unable to process it fully. Therefore, he may hand it over to some other person for the purpose of processing. Now, one of the things that is objected to is breach of the privacy. When is it breached? When data is unauthorizedly leaked out, it is called a breach of the right of privacy. It can happen at several points. At the point at which I first gave the data for processing, or at any further point where my data is handed over from hand to hand for processing. So you will have to ensure that there is no leakage anywhere along the line. That is one of the requirements of any law. The other can be that for what purpose is the data given? Data is given, let's say I'm going to the railway station for booking a ticket. I'm booking a ticket, therefore he is only concerned with whatever is necessary to effectively complete the transaction of booking the ticket. I go to a sari shop to buy a sari for my wife. He is only concerned with the transaction. At the most, he may ask me what color my wife likes or what color she does not in order to choose a good sari for me. But he has nothing to do with my eating habits. He has nothing to do with my health records. He has nothing to do with my educational qualifications. Therefore, this doctrine is known as the doctrine of limitation or the purpose limitation. So when the data is given, the data should be taken only as much as is necessary for the purpose which is to be transacted. Beyond that, he cannot go. That is why I would call it thus far and no further. Second principle is that how long is the data to be remain in your hand? Let's say I open a bank account today. The bank takes a whole lot of data. 6 months down the line, I have no use for the bank account or I don't like the bank's handling of my account. I want to terminate the account. I go to the bank manager and say, hey, close my account. He closes the account. What happens then? My data remains on his computer. I have a right as a data principal to tell him, hey, no, the purpose is over. When the time limit was, as long as it was necessary, it was there. Now the necessity is gone. Therefore, you delete the records. But then there will be one little difficulty to which you have to agree. The difficulty is under the law of this income tax law of this country, everybody has to maintain records for a period of 7 years. So he will say, sir, my income tax account wants me, income tax department wants me to maintain for 7 years. For even if you close the account today, I will maintain it for 7 years from the counting from the date on which you first opened my account. That is justified. So the data would have to be kept and deleted at the option of the data principal unless there is a law which requires the data to be carried out for a beyond the time limit specified, and in this case the law will take the precedence and you will have to keep it for keep it alive for that period. Then there are again certain exceptional situations where data may be processed without consent. Now, for example, minor. What happens to the law in this country, right from the Privy Council's judgment in Mohri Bibi's case, has been that a minor's consent does not bring about a contractual transaction. The contract would be void throughout. I take it that void means something which can never. It's like a dead person. You have no way of resurrecting him. So, and don't forget that all processing of data is a contractual transaction. I go to somebody because I have a commercial transaction, I give him some money or he gives me some money and the transaction takes place. So if a minor were to enter into a contract, what happens? That has been one of the major issues which has bothered lawmakers all over the world. And each country, depending on its own genius, has answered it in a different manner. Now, should minors should have access to data processing contracts or not? If you had asked me 10 years ago, I would have said not at all. But today, what has happened is, whenever you have children who are exposed to internet, they would like to enter a website and have a transaction. Some of which may be good, a lot of which is good, and a lot of which is bad also. Now, for example, there are many websites which offer online courses. Now, before entering it, a whole lot of data is required to be given. And you all know this. Click and say yes on the computer for all those agreements of all the websites. So when that consent is given by the minor, is it binding on the minor? Is it binding on the person whose website is operating the website? Or is it a void contract? Would make a lot of difference in commercial transactions. So we had to draw a line somewhere and say, what should be the age of minority? Now, only one problem is some of the online transactions, some of the online educational institutes offer education right from very young age to the kids. Now, I know my grandson operates the on the Khan Academy, and he learned a lot of good things which they wouldn't even teach them in, or maybe another 5 years down the line they would teach him in the school. No, that is something to be encouraged. Now, how do you draw the distinction? Because if you have a form which says, what is your date of birth? The kids are so smart, they'll tailor the date of birth in such a manner that it will always show the majority age. Or if you say, always get the parents' consent, which is impossible because the parents may be somewhere else, the parents may be busy working, parents may be not available for immediate transaction. Therefore, we had to grapple with a whole lot of such things. And finally, what is the age of minority and majority in this country? Unfortunately, that is also not definite in this country. You can get married at one age, you can start drinking alcohol at another age, you can start smoking cigarette at another age, and for contractual purposes, it is 18. We said all right, we'll accept 18. If Parliament wants sometime along the line, they may reduce it into what like. So we proposed there that 18 should be age of majority, and anybody less than 18 will be treated as a minor. Now, for, what happens if you want to get to this, what is this, Manrega or one of those benefits that the state is given? If you remember, when Aadhaar judgment was given, just before that, every private company, every individual was asking for Aadhaar number, Aadhaar notification. The Supreme Court came down heavily on that and said, nobody, not even the government, can ask for Aadhaar unless the citizen wants some benefit, in which case the government will be justified in asking, not private companies. Even today, the private companies have no business to ask your Aadhaar card. So that means in a situation where the state, the government, is giving you benefits, they can ask for your data, which would not amount to infringement of your data privacy. And then data can always be taken away with your consent for processing and prevention of detention without your consent in the case of whistleblowing, prevention of crime investigation, etc. As I told you, all processing has to be done with the consent of the data principals, and not doing it without the consent of the data principal would amount to a breach of your data privacy, which is actionable under the law to the extent I will indicate now. Then the law also has taken into account what would be the rights of the data principals and what should be the obligations of the data processors. What are your rights as a data principal? The right of information and access. At any time, I should have the right to go to a person who is holding my data and say, are you holding my data? What is the data that you're holding? Make sure that it is correctly held, that update it properly, and don't allow it to get corrupted. So that is my right. Then this is concept of data portability. Now, all of you are familiar with your mobile number portability. This also operates like that. If data is held by X, I can always say that, sorry, I don't want to transact with you, transfer it to Y. Only problem then is, what is the method, the technical method in which the data is being, is it portable, feasibility or interoperability is possible or not. Subject to that, there is a right of portability. Then finally, there is also this right to be forgotten. I don't see any reason why, as I gave you the example of my bank account, I don't want to be on your bank account records at all, because I don't want to have transaction with you is one good way. I can say, I'm sorry, I don't want it at all. Then there is this concept of privacy by design. It is something like, if you remember, the Supreme Court gave a historic judgment in Vishakha's case. Vishakha's case was the first case which recognized that this exploitation, sexual exploitation of women at the work spot was objectionable, and it was contrary to our fundamental rights. It was contrary to the UNHCR Declaration of Human Rights. It was contrary to the human rights legislation, and therefore it had to be stopped by a methodology. And then, of course, later on, it has been very much later, it's been enacted into an act which protects the women from exploitation. The question there is, every one of the companies or employers are required to educate their employees as to the importance of the subject, have these proper committees, etc., etc., etc. Similarly, in right to privacy, the privacy by design concept is that every person who has or stores or processes data must educate the persons with whom he deals with day to day as employees of the most important necessity of having to protect the data of the persons from the data principles from whom the data has been collected. Put in place such cyber security measures as would effectively safeguard the security of the data processed. Ensure against breach of privacy data. These are all the obligations under the privacy by design. Carry out periodical assessment of the data protection impact. Appoint a qualified data protection officer to ensure compliance with the obligation. Then maintain appropriate records so that in case they have to be audited, there are enough records. Then carry out periodical data auditing as prescribed by what is an authority known as the Data Protection Authority. I'll come to it in a moment. Only engage for others for processing data under valid known as the Data Protection Authority. I'll come to it in a moment. Only engage for further processing of data by transferring it to another person. And also have a grievance redressal mechanism as well prescribed by the law. Now, these are all the necessities of what is called privacy by design. If you want to collect data, then you must be obliged to do it. The law will. Then, how is all this to be ensured? Now, any business transaction regulated, for banking or payment systems, you have the Reserve Bank which is regulated. If you are doing insurance contract, you have the IRDA which is regulated. If you are doing capital market transactions, you have the Securities and Exchange Board of India, or the SEBI as it is called. Now, therefore, or if you are doing financial transaction systems, you have the Reserve Bank which is you have the Securities and Exchange Board of India. If you want, or if you have a company's transaction, then you have this to be ensured. Any financial transaction.
Looks like we are again losing your voice.
You have the insurance contract. You have the IRDA. What do I do? I have already cut off my video. Now, shall I cut off my opportunities?
No. We can't really do that.
So what will I do? This is one of the, in fact, I votary of doing even court hearings by this. Votary of doing even court hearings by this, provided video and the audio is intact. Otherwise, imagine I'm hearing a fundamental rights case in the Supreme Court and suddenly the audio goes like, what will it do? This is always the problem. Anyway, am I okay now? Am I audible? Bhupesh, am I audible?
Yes, you're audible, sir. Little bit some break, but we will manage it, sir. Your talk is so interesting. We all are glued to your talk.
Okay. Sorry. Therefore, it is absolutely necessary that you should have a regulator who will be able to regulate and monitor the transactions. Now, if it is not there, now, for example, if the Reserve Bank were not there, even with the Reserve Bank, we have seen all the frauds that take place. If the Reserve Bank were not there, every day your money would be lost. Similarly, there is necessity of having a regulator, and that regulator is called the Data Protection Authority. The job of the Data Protection Authority is to ensure that in every state there will be a subordinate Data Protection Authority whose job will be to interact with all the stakeholders and different sectors. Now, for example, you know that the necessity of data protection is different and varies from sector to sector. If you can imagine, the data of hospital industry is very sacrosanct. Therefore, there has to be a greater method of monitoring it and controlling it. The data of a shoe manufacturer or a lipstick manufacturer may not be of such great necessity to be protected. Therefore, in each of these sectors and industries, the Data Protection Authority, his job is to interact with all the stakeholders, find out what are the best practices adopted in the industry, and after consent with them, formulate into the form of a common practice, notify it in a public domain, and then after receiving all inputs from all affected persons, formulate regulations which will control the operation, the transactions with regard to data to ensure data privacy and there is no data breach. So this is the job of the Data Protection Authority, and the manner in which is to be appointed, who is to appoint, who is to buy, what is the salary and all that, the law will determine all that. That is not very important from our point of view. Then I come back to data fiduciaries. Now, I told you various obligations they have. One of the obligations is that you will not accept data unless you are in a position to protect data in the manner that the law asks you to do. You will make sure that the data is maintained, is updated, and always correct. You will ensure that there is no data leakage, that there is no data breach, that data is not lost or corrupted. These are all the obligations of the data fiduciary who accept data for processing. Now, data fiduciaries also may be of different types because the law will treat differently. For example, as I was mentioning, the corner pawn shop wala is not to be treated as the same as a giant industry like Tata's or Reliance or anything like that. Therefore, even though the law may be there, the application of the law to this person will be proportionate to their capacity to deal with it. How is it done? Now, depending on the type of data processed, volume of data processed, likelihood of harm in case of breach, turnover of the entity, use of use of technologies, updated technologies, and so on, the Data Protection Authority may classify the fiduciaries into several categories and prescribe different obligations upon them. This is absolutely necessary. Now, if you see, we are all aware of the Bhopal gas tragedy, and recently we had this in somewhere in South India also, Mysore, no sorry, Madras, Andhra Pradesh, where gas leaked out and all that. Now, a person who manufactures very serious, complicated, uses complicated machinery to manufacture some chemical which is very deleterious to human life should have greatest amount of restrictions put on him, greatest amount of safety requirements. Whereas another factory which learns, which does not have any such difficulty, should have lesser amount of restrictions put on their activity. This is exactly to be determined from case to case, from industry to industry by the Data Protection Authority. So that will be the job of the Data Protection Authority. Now I come to another interesting thing which has created a lot of controversy. What is known as cross-border transfer of personal data. Now, first let me point out why the controversy arises and how it has been sought to be solved by the government in the latest bill, and whether they have been able to solve it at all. See, one of the things that immediately struck us in the committee was there are a number of international companies which Mr. Bari, how much time do you have? Mr. Daria. Hello.
Sir, we are able to hear you, sir.
You can hear me?
Yes, sir. We have 10 minutes left. A couple of questions, if you permit, sir. There's some couple of very interesting questions which has come.
How much time do you want for questions? Then I'll find it up soon.
We have 10 minutes. We are left with 10 minutes, sir.
Okay. I'll try to wind it up. There's not much. Now, one of the things is all the international companies maintain the data on servers outside the company. It may be in Timbuktu, it may be in Germany, it may be in the United States. Now, the question that arises is, if under a validly enacted law by Parliament, if there is a necessity to access somebody's personal data, the company will say, sorry, sir, the data is not here at all. It is somewhere in Timbuktu. And you go, you can't take it from Timbuktu because then if you want to go, you have a long process called the mutual legal assistance treaty, in which it takes about 2 years to get anything from any other country. So, therefore, we were suggesting that all data may be kept wherever you like, but keep one live copy here so that the live copy is within the Indian jurisdiction and the Indian authorities have immediate access to it. And number two, so much of data is available here. If necessary arises, we can use it for data analytics here instead of allowing Facebook or some other company elsewhere, Google or some other company to use it and prosper on that. Why not allow our companies to prosper? That was the whole idea. But that was objected to principally on the ground that it will impose greater business costs, which according to me is not a very serious argument, because any law that is passed by any country is bound to have repercussions on business costs. Now, there is now I'll come straight away to what has happened under the bill that has been in the bill that we had submitted, draft bill that we had submitted. We said that the government, meaning the state, should not have access to personal data of any person unless it is preceded by a parliamentary enactment which is enacted on the lines given by the Supreme Court in the Puttaswamy case. So we had put it negatively and said no data shall be accessed by the state on this ground unless there is a parliamentary enactment or a statutory enactment, and these principles are embedded in that. The whole idea is that this is a fundamental right derivable from Article 21, and like any other infringement of Article 21, it has to be subject to severe restrictions. And the law in this country has been that no fundamental right can be restricted by mere executive fiat. It has to come by a warrant of a parliamentary enactment, which must say why I am restricting it, how long I will do it, what is the process, and all that has to be there in the law itself. Now, apparently, the government of India, I don't know, the security agencies were able to persuade the government, and this restriction has been completely done away with it. And the act merely says that if somebody, some secretary or somebody certifies and says it is necessary in the security of country, or it is necessary in the interest of maintaining good relations with foreign countries, that is sufficient to accept your data and mine without any further ado. Whether that is sufficient, whether that will pass the test of constitutional validity is a big question, and I have always said that if you allow this kind of a law to continue, it will amount to 1984 Orwellian state. Finally, I come to 2-3 things that they have done. One is there are no constitutional safeguards in the bill that has been submitted to Parliament and then no passed on to JPC. Then there is no definite date of commencement there. It only says it will come into operation on such date as the government executive may certify. Now, if the executive does not notify it for next 25 years, you will not have a law for the next 25 years. And then critical data is also not defined there. Then on the localization, the solution that they found to this objection from foreign companies is neither here nor there. They are saying that, all right, you may process it elsewhere with the consent of the data principal, but then in such case you will have to have a copy here, which I don't know whether they have solved the problem, the objection raised by us or the objection raised by the foreign companies, or neither. Then finally, you have access to non-personal. This is something very serious there. The act is called Personal Data Protection Act, which was intended to cover only personal data and how to protect it. We had considered carefully in the committee that this was not the non-personal data is something of a larger issue, and that should be carefully again looked at by some other expert body, and then finally a law made to that. Unfortunately, one section has been sneaked into the bill by which it says that if the government wants, it can come out and take away all the non-personal data. What is non-personal data? Non-personal data may be of 2-3 types. One may be financial data. The other may be IPR. Of course, IPR is covered by the intellectual property laws. Then you are supposing a company wants to know what should be its business strategy. How should it meet or beat the competition? those may be discussed in some committees, discussed in some board meetings, and minuted for better execution. All that can be taken away as data, and that is a very disastrous thing to allow the government access to all that without, and that too in the guise of operating under the personal data protection. That has nothing to do with personal data. Finally, and there is also one section which allows them to indirectly control intermediaries such as your WhatsApp and people who transact like the Snapchat or etc. Your social media. So the right to control social media without an open legislation is being sought under this by a very indirect method. These are some of the basic objections that I have raised, I have pointed out, and I think that brings me to an end. I'm open to questions now, for as long as Mr. Deharia will permit.
No, sir, your points are so interesting points, and I think everybody was glued to listening to your talk. And first of all, we all are thankful to you. I would not congratulate, but we are so grateful and thankful to you that you have brought this point to the government, and you have been able to really put a lot of major scenarios. You have covered almost everything, right from right to data, portability of the data, right to forget the data, privacy by design, and then forcing overseas companies to keep the copy of the data. And I think under those lines, Google, AWS, all these companies, they have started setting up their data centers here in India. And thank you so much, sir. This is all your efforts.
From their point of view, everybody
and these things were quite important, that yes, we could really hold the Indian data right over here. Now there is a very interesting question, and in fact it's in the lines what you have commented and some of the points you have covered. Ambika is saying that the danger to privacy originates from the states and non-state actors. And in fact, you have given a couple of points how it originates. You said very well, it points out that the government cannot have access to the personal data, but the personal data is every Indian's fundamental right. Now, which are the cases where government can really violate this right and access the data, other than we being in or any crime?
No, the government can say, make a declaration and say, I need to access your data for the purpose of protecting security. That is not sufficient. You can do it provided there is an act which allows you to do it, a parliamentary enactment or state legislation, subject to the constitutional provision. And the object. Also, it must also say for what purpose it is being done, how it is being done, and what it will be done. Otherwise, anybody in the government may issue police constable can take away.
I think, sir, both of us, we have to stop our video, sir. At least we'll have a good audio. Some voices started cracking.
Okay. Okay. It was declared object. Also, it must also say the so that's it.
Yes, sir. So, sir, the question was how the government can, on what circumstances government can really have access to our personal data.
That is why I'm saying, first of all, they have to pass a legislation, and that legislation has to be constitutionally valid. It will be constitutionally valid if it follows the three principles that have been enumerated in the long judgment of Puddaswamy. As to declaration, proportionality, and methodology, all that has to be stated. Now, where is it stated? It's stated nowhere.
But in case if somebody is involved into any terrorist activities or any crime,
it is possible to say they should be the terrorist control activity. Like you had your earlier, you had no TADA, PODA, and all that. You can have an act saying that you can have one act which will say how, under what circumstances, can personal data be accessed without consent of the data principal, and lay down all the parameters there. And somebody will test in the court and say whether it is constitutionally valid or not. But today there is no law at all.
No, thank you, sir. Thank you so much for your insights, and again, congratulations and for bringing this kind of awareness about data, because none of us we were aware about the data. We were just sharing our data on various sites. We were getting a lot of interesting questions, sir. Unfortunately, this is a very short time. We'll hold you again for some other time and try to really hear your thoughts, sir. Thank you so much and have a nice day, sir. Thank you so much. Yeah. And we have Dr. Manish Gupta now.
Dear delegates, we have Dr. Manish Gupta. We have both the sessions.